We back in number 14, false certification of checks. It shall be unlawful for any officer, clerk, or agent of any bank admitted to membership under authority of this section to certify any check drawn upon such bank unless the person or company drawing the check has on deposit therewith at the time such check is certified an amount of money equal to the amount specified in such check. Any check so certified by duly authorized officer shall be a good and valid obligation against such bank, but the act of any such officer, clerk, or agent in violation of this section may subject such bank to a forfeiture of its membership in the Federal Reserve System upon hearing by the Board of Governors of the Federal Reserve System. 12 United States Code 331. 15. Government depositories and financial agents. All banks or trust companies incorporated by special law or organized under the general laws of any state which are members of the Federal Reserve System, when designated for that purpose, the Secretary of the Treasury shall be depositaries of public money under such regulations as may be prescribed by the Secretary, and they may also be employed as financial agents of the government, and they shall perform all such reasonable duties as depositaries of public money and financial agents of the government, as may be required of them. The Secretary of the Treasury shall require of the banks and trust companies thus designated satisfactory securities by the deposit of United States bonds and otherwise for the safekeeping and prompt payment of the public money deposited with them, and for the faithful performance of their duties as financial agents of the government. 12 U.S.C. 332. 16. Admission to membership of mutual savings banks. Any mutual savings bank having no capital stock, including any other banking institution, the capital of which consists of weekly and other time deposits which are segregated from all other deposits and are regarded as capital stock for the purposes of taxation and the declaration of dividends, but having surplus and undivided profits not less than the amount of capital required for the organization of a national bank in the same place, may apply for and be admitted to membership in the Federal Reserve System in the same manner and subject to the same provisions of law as state banks and trust companies, except that any such saving bank shall subscribe for capital stock of the Federal Reserve Bank in that amount equal to 6/10 of 1% of its total deposit liabilities, as shown by the most recent report of examination of such saving bank proceeding its admission to membership. Thereafter, such prescriptions shall be adjusted semi-annually on the same percentage basis in accordance with rules and regulations prescribed by the Board of Governors of the Federal Reserve System. If any such mutual savings bank applying for membership is not permitted by the laws under which it was organized to purchase stock in the Federal Reserve Bank, it shall, upon admission to the system, deposit with the Federal Reserve Bank any amount equal to the amount which it would have been required to pay in on account of prescription to capital stock, whereafter such deposits shall be adjusted semi-annually in the same manner as prescriptions for stock. Such deposits shall be subject to the same conditions with respect to repayment as amounts paid upon prescriptions to capital stock by other member banks, and the Federal Reserve Bank shall pay interest thereon at the same rate as dividends are actually paid on outstanding shares of stock of such Federal Reserve Bank. If the laws under which any such saving bank was organized be amended so as to authorize mutual savings bank to prescribe for Federal Reserve stock, such savings bank shall thereupon subscribe for the appropriate amount of stock in the Federal Reserve Bank, and the deposit herein before provided for in lieu of payment upon capital stock shall be applied upon such subscription. If the laws under which any such savings bank was organized be not amended at the next session of the legislature following the admission of such savings bank to membership so as to authorize mutual savings banks to purchase Federal Reserve Bank stock, or if such laws be so amended and such bank fail within 6 months thereafter to purchase such stock, all of its rights and privileges as a member bank shall be forfeited, and its member bank in the Federal Reserve System shall be terminated in the manner prescribed elsewhere in this section. With respect to state member banks and trust companies, each such mutual savings bank shall comply with all the provisions of law applicable to state member banks and trust companies, with the regulations of the Board of Governors of the Federal Reserve System, and with the conditions of membership prescribed for such savings bank at the same of admission to membership, except as otherwise hereinbefore provided with respect to capital stock, codified in 12 United States Code 333. 17. Reports of affiliates. Each bank admitted to membership under this section shall obtain from each of its affiliates other than member banks and furnish to the Federal Reserve Bank of its district and to the Board of Governors of the Federal Reserve System not less than 3 reports during each year. Such reports shall be in such form as the Board of Governors of the Federal Reserve System may prescribe, shall be verified by the oath or affirmation of the President or such other officer as may be designated by the Board of Directors of such affiliate to verify such reports, and shall disclose the information hereinafter provided for as the dates identical with those fixed by the condition of the affiliate member bank. Each such report of an affiliate shall be transmitted as herein provided at the same time as the corresponding report of the affiliate member bank, except that the Board of Governors of the Federal Reserve System may, in its discretion, extend such time for good cause shown. Each such report shall contain such information as in the judgment of the Board of Governors of the Federal Reserve System shall be necessary to disclose fully the relations between such affiliate and such bank, and to enable the board to inform itself as to the effect of such relations upon the affairs of such bank, and the reports of such affiliates shall be published by the bank under the same conditions as govern its own conditions report. That's codified at 12 U.S.C. 334. 18. Additional reports and of affiliates. Any such affiliated member bank may be required to obtain from any such affiliate such additional reports as in the options of its Federal Reserve Bank or the Board of Governors of the Federal Reserve Bank may be necessary in order to obtain a full and complete knowledge of the condition of the affiliate member bank. Such additional reports shall be transmitted to the Federal Reserve Bank and the Board of Governors of the Federal Reserve System, and shall be in such form as the Board of Governors of the Federal Reserve System may prescribe. Codified at 12 U.S.C. 334. Failure to obtain reports of affiliates. Any such affiliate member banks which fail to obtain from any of its affiliates and furnish any report provided for by the two preceding paragraphs of this section shall be subject to the penalty of $100 for each day during which such failure continues, which by direction of the Board of Governors of the Federal Reserve System may be collected by suit or otherwise by the Federal Reserve Bank of the district in which such member bank is located. 12 U.S.C. 334. 20. Dealings in investment securities and stock. State member banks shall be subject to the same limitations and conditions with respect to the purchasing, selling, underwriting, and holding of investment securities and stock as are applicable in the case of national banks under paragraph 7th of section 5136 of the revised statutes as amended. This paragraph shall not apply to any interest held by the state member bank in accordance with section 5136A of the revised statutes of the United States, and subject to the same conditions and limitations provided in such section. 12 U.S.C. 335. 21. Stock representing stock of other corporations. After the date of the enactment of the Banking Act of 1935, no certificate evidencing the stock of any state member bank shall bear any statement purporting to represent the stock of any other corporation except a member bank or a corporation engaged on June 16, 1934 in holding the bank premises of such member bank, nor shall the ownership, sale, or transfer of any certificate representing the stock of any state member bank be conditioned in any manner whatsoever upon the ownership, sale, or transfer of a certificate representing the stock of any other corporation except a member bank and a corporation engaged on June 16, 1934 in holding the bank premises of such member bank, provided that this section shall not operate to prevent the ownership, sale, or transfer of stock of any other corporation being conditioned upon the ownership, sale, or transfer of a certificate representing stock of a state member bank. 12 U.S.C. 336. 22. Examination of affiliates in connection with examinations of state member banks. Examiners selected or approved by the Board of Governors of the Federal Reserve System shall make such examinations of the affairs of all affiliates of such banks as shall be necessary to disclose fully the relationships between such banks and their affiliates, and the effect of such relations upon the affairs of such banks. The expense of examination of affiliates of any state member bank may, in the discretion of the Board of Governors of the Federal Reserve System, be assessed against such bank, and when so assessed, shall be paid by such bank in the event of the refusal to give any information requested in the course of the examination of any such affiliate, or in the event of the refusal or permit such examination, or in the event of the refusal to pay any expense so assessed. The Board of Governors of the Federal Reserve System may, in its discretion, require any and all state member banks affiliated with such affiliate to surrender their stock in the Federal Reserve Bank and to forfeit all rights and privileges of membership in the Federal Reserve System as provided in this section, as codified at 12 United States Code 338. 23. Investments to promote the public welfare. 23. A state member bank may make investments directly or indirectly, each of which is designed primarily to promote the public welfare, including the welfare of primarily low and moderate income communities and families, such as by providing housing services or jobs to the extent permissible under state law. A state member bank shall not make any such investment if the investment would expose the state member bank to unlimited liability. The board shall limit the state member bank's investment in any one project and a state member bank's aggregate investments under this paragraph. The aggregate amount of investments of any state member bank under this paragraph may not exceed any amount equal to the sum of 5% of the state member bank's capital stock actually paid in and unimpaired, and 5% of the state member bank's unimpaired surplus, unless the board determines by order that a higher amount will pose no significant risk to the effect deposit insurance funds, and a state member bank is adequately capitalized. In no case shall the aggregate amount of investments of any state member bank under this paragraph exceed an amount equal to the sum of 15% of the state member bank's capital stock actually paid in and impaired, and 15% of the state member bank's impaired surplus. The foregoing standards and limitations apply to investments under this paragraph made by a state member bank directly and by its subsidiaries. 12 U.S.C. 338A. We had section 9A, participation in lotteries prohibited. Participation in lotteries prohibited. Okay, I'll read this one. 1. Prohibition against participation in lotteries. A state member bank may not 1. Deal in a lottery ticket. 2. Deal in bets used as a means or substitute for participation in a lottery. 3. Announce, advertise, or publicize the existence of any lottery. 4. Announce, advertise, or publicize the existence or identity of any participant or winner of such in a lottery. B. A state member bank may not permit 1. The use of any part of any of its banking offices by any person for any purpose forbidden to the bank under subsection A, or 2. Direct access to the public from any of its banking offices to any premises used by any person for any purpose forbidden to the bank under subsection A. C. As used in this section, 1. The term dealing in includes making, taking, buying, selling, redeeming, or collecting. 2. The term lottery includes any arrangement other than a saving, promotion, raffle, whereby 3 or more persons, the participants, advance money or credit to another in exchange for the possibility or exception or expectations that one or more, but not all the participants, the winners, will receive by reason of their advances more than the amounts they have advanced. The identity of the winners being determined by any means which includes A. A ransom selection, B. A game, race, or contest, or C. Any record or tabulation of the result of one or more event in which any participant has no interest except for its bearing upon the possibility that he may become a winner. 3. The term lottery ticket includes any right, privilege, or possibility, and any ticket receipt, record, or other evidence of any such right, privilege, or possibility of becoming a winner of in a lottery. 4. The term saving, promotion, raffle means a contest in which the sole consideration required for a chance of winning designated prizes is obtained by the deposit of a specified amount of money in a saving account or other savings program where each ticket or entry has an equal chance of being drawn. Such contests being subject to regulations that may from time to time be promulgated by the appropriate prudential regulator as defined in Section 102 of the Consumer Financial Protection Act of 2000 10. Definitely want to look that up. So pause. And that's codified at 12 USC 5851. D. Nothing contained in this section prohibits a state member bank from accepting deposits or cashing or otherwise handling checks or other negotiable instruments or performing other lawful banking services for a state operating a lottery or for any officer or employee of that state who is charged with the administration of the lottery. E. The Board of Governors of the Federal Reserve System shall issue such regulations as may be necessary to the strict enforcement of this section and prevention of evasion thereof. That's 12 USC 339. Whenever I come back, I'm going to be at section 9B, resolution of clearing bank. Resolution of clearing bank.